Hi, I'm Matt Prewitt. I'm with the law firm of Schiff, Hardin in our Chicago office and our general litigation practice, and I'm also a member of the firm's e-discovery committee.
My name is Jonathan Sherman. I'm a principal here at Shelist in Chicago, and I practice in the litigation group. The decision in the race tires case really narrows the scope of what a court is going to consider to be a recoverable cost in litigation. It's important that counsel work creatively and proactively, both with opposing counsel in a lawsuit as well as with his or her own client, to narrow the scope of discovery and to tailor discovery requests so that costs don't get out of hand.
The problem that I see, though, is that Rule 59 is not really calibrated to address effectively the issue of cost shifting. And what I would suggest is a better approach would be a more aggressive use of cost shifting on the front end under Rule 26, 26B or 26C.
Another alternative approach is to set up a motion before the court asking for a protective order that either limits the overall scope of discovery that can be taken or establishes a time frame for taking that discovery. It's an extraordinary burden on GCs to try to control costs, particularly in the economic times in which we find ourselves.
The problem of proportionality arises typically when you have two parties who are not playing on a level playing field.
I would suggest that in-house counsels be very upfront with their outside attorneys, ask for frequent updates on what's happening with discovery, both in terms of the scope of discovery and the cost of discovery, and really get a clear-cut idea from their outside counsel as to why certain discovery is being taken and is needed.
And what you see in a case like race tires is you have one side that is pushing for discovery much more aggressively than the other side, and a burdens of discovery being allocated unfairly.
There are some lawyers who don't have an extensive background in business. They've never been on the inside of a company. They've never had to balance a budget. They don't know what it means to control expenses. And their understandable reaction when getting involved in a lawsuit is to be as aggressive as possible. When you're talking about a case that may involve hundreds of thousands or even millions of pages of electronic documents, that approach simply is no longer feasible.
The best way to achieve proportionality is to try to level that playing field in some way. A motion for reallocating the cost of discovery is one way to do that. The other way to address that is the way that I think attorneys have been dealing with discovery disputes since long before anyone heard of e-discovery, which is trying to work out the discovery conflicts in the context of a general case management plan.